One matter vigilance challenge the order of accuser. From the accused, he has acquitted 2011. He has retired 2021. His matter is pending. Your lawsuit adjourned this matter at 12. His daughter's study loan is required, and 20th is the last date. Your lordship,
You have been acquitted, then how does it make difference?
ସେମାନେ କହୁଛନ୍ତି ଏଇଟା ଆମେ ଦବୁ ଯେହେତୁ କେସଟା ପେଣ୍ଡିଂ ଅଛି ସେଥିପାଇଁ ଯଦି ଟୁ ବି ମେନସନ ଆସିଲା ସାର୍ କ୍ୟାନ୍ ବି
You have already been acquitted. If somebody has filed,
ଦଉନାହାନ୍ତି ସେ ଡକୁମେଣ୍ଟ ଦେଖେଇଦେବି
show me.
ସାର୍ ସାର୍ କାଲି ସକାଳେ ସେମାନେ ଦେଖେଇଦେବି
You bring it and then
ସାର୍
Pardon to mention one matter. Matter was misstated. One IU has been allowed. Fine has been suspended. The matter is posted to the 14th of next month, Your Lordship. The urgency is, Your Lordship, the mother is involved in the death bed, Your Lordship. The last case.
you move application, interim application.
No, Your Lordship. IU was allowed that day was posted for hearings. Could not be taken up because my learning pen did not have
It's
copy.
an
there.
interim application.
No, Your Lordship, this is 3 name there.
But you move an interim bail application also and mention it. I'll take it up Monday.
Please, Your Lordship.
You move it. Interim bail application on the ground of health ground of mother.
Monday, Your Lordship. Your Lordship.
You move it today,
Yes, Your Lordship.
mention it tomorrow,
Please.
I'll take it up.
Okay.
Ah.
Your
No,
Lordship.
interim bail. Therefore, I'm saying interim bail.
So because that IU could be taken.
I can't suggest you. I'm not
Pardon.
sitting here to advise you. I give a suggestion, you do it or don't do it. That's your problem. Yes.
You know, so vigilance case not been listed since last 7 years.
Huh?
Not been listed since last 7 years.
2022 matters compromise matter.
Offense?
Offense is 428.
It is third successive memo. A prisoner with lordships are in-laws. 490-304 victim committed suicide by taking poison. They were thrown out on bail during trial. After the conviction since 2024 in custody. Both are in-laws, father-in-law and mother-in-law.
Or bail?
More than 1.5 years out of 5 years. Section is 354 of IPC.
Okay, you keep.
My lords, I may be permitted to make a mention, my lords, through VC, my lords. My lords,
1 minute, one minute.
Brutally mixed the entire item number 62. It's a vigilance matter. Can it be taken up any day suit into a lordship convenience?
I am trying to work out with vigilance council. We will fix a date.
I prepared a note. I'll just take 2 minutes. Because I'm covered by your lordship's 4th judgment.
Let us see. I'll see.
I don't know, item 7, supplementary, I don't know, my operative party manner. I played for
Today,
item 7,
today's date.
today list.
Adjournment. Oh,
It was 7th September.
don't give the date.
Adjournment, my lord will give.
Don't you decide everything, then why should you come then? Well, get the judgment, I'll sign. I will have to see my board also.
As per your convenience.
To
Well,
see.
I have no objection.
Give a date. It's on the script.
my lords, I may be permitted to make a mention, my lords.
Take the steps. Sir. Notice not sufficient. Steps.
My lord, from the list, item number 3, my lord. Permitted to withdraw, I have already filed the withdrawal memo.
To supplementary list.
My lord,
Okay. Yes.
withdrawal memo is at flag B.
Yes.
Item,
In terms of yes.
for item 1, here both.
I'll take up. Let us.
Yes,
completely
My
mention.
lords, I may be permitted to
Item
mention, my
flag,
lords.
instruction for the 164 statement.
1 minute. I'll mentioning should be over there after item 1. Wait.
No, I was.
Why are you mentioning item 1? I don't understand. Wait. Yes.
My lords, CRLA number 1162 of 2023, my lords, I have filed for interim bail, my lords. The wife is very ill, my lords. Offense under 376.
Give a memo. Give a memo.
First, my lords.
Interim bill. Yes.
Can it be tomorrow, my lords?
Not tomorrow. We'll see. But what is the ground?
My lords, the wife is very ill. She is
Why?
bleeding for continuous.
Give a copy. Let him get the.
Already served, madam.
Already served, my lords.
You just see. Get the instruction. Health ground. Give it. Yes. Which police station?
Odoga, my lords.
Odova.
Odoga.
Yes.
Pardon to mention, my lord, item 42 and 45 of the weekly list also kindly be taken up after the supplementary. Senior will argue the matter. This matter.
One.
So senior will argue the matter today. Item 42 and
Okay, let it come. We'll see. Yes. Yes, Mr. Ponda, are you mentioning something? You have
My lords,
unmute. Yes, ma'am.
Your Lordship has admitted 2 criminal appeals, 445 of 26 and connected matters, my lords. They were directed to be listed on 24/7. They have been directed to be listed on 24/7, 2027. But when IA is pending, my lords, regarding that attachment procedure, my lords, no orders have been passed.
Give the memo. We'll see.
I'll give them,
Give them.
my lords.
Yes.
And I have got some matters in the list, my lords.
Let us see, because there is a larger bench also today.
I see.
Madam, to mention that the applicant has remained in jail custody more than 6 years out of 10 years. During trial, he was granted interim bail twice and he has surrendered. What I am submitting, what is the matter? This court bench has granted interim bail for a period of 3 months, which was going to expire on 17/7/2026. Due to viral fever, he could not surrender. Time petition was filed before the London Third Additional Session of Bhubaneswar, but he refused my interim application and also the medical certificate. Only he has issued evidence. On 22/7, when the
You have to surrender.
but he is not accepting surrender. That is my sole prayer. 22/7/2026, you want to surrender since I have issued evidence and not accept the surrender. You brought the order for the tomorrow, Monday, as your lordship. Only to accept the surrender.
That is.
Tomorrow, Monday, as your lordship.
Yes. Chat, item 1. Yes.
It's item 1, my lord. You know, after the directive take instruction as to whether 164 treatment of the victim is recorded or not. This morning we are talking to trial court advocate. That's why I want some time so that NDPS request. Week after, so that I will take instruction
Week
and
after.
produce the same.
Yes.
Item 2.
Item 2, my lord.
Yes.
Well, I have filed one IA 2155 of 26. I had filed an application for modification and the state opposed it. They have filed an application to recall in my learned seniors. I have filed an IA for recall of the last paragraph of the order passed by your lordship.
I understand. I know that.
Yes.
3, 4, 5, 6.
Yes. And 7.
7. Of immoral trafficking is not made out.
Not made. My senior has
Yes.
in fact argued everything.
This application is now.
The IFR may both claim that modification are how this.
No, it is substantive application now. You have to tell me whether 3, 4, 5, 6 and 7 aapko immoral trafficking is made out.
With the dear apology, I have gone through the entire things that 3, 4, 5, 6 is
Not made out. Then
once the judgment has been rendered.
that's a different story.
That-
Now,
up
since
to
it's not
that-
made out, why unnecessary?
Up to that, it is up to your lordship may decide. My submission after judgment.
I'll pass you.
Great.
Also, judgment very good, your lordship can recall your lordship also. That your lordship wanted me to give.
The recall is entirely on 3390. My humble submission of this order should recall. Then your lordship pass on merit. Then there is no.
Why to get into technicality? Unnecessary, the trial court will be burdened. And you can't substantiate your case.
Then your lordship.
Only on technicality, they have to face the trial, and at the end of the day, they will be acquitted. It is burden on the system.
I am not. Your lordship pass whatever order in my post client.
Maybe you may have a case also. Technically, you may have a case, but let us be practical. Why unnecessary getting into all this
I'm
thing?
actually sorry, my lord. I'm exchanging it, my lord. Here paragraphs have been written. Which para, your lord?
In fact, my lord, in my judgment, your lordship has categorically held on the statement
Paragraphs, my lord, sir.
from the charge sheet that those girls were not even put under 161.
Those girls have gone already.
They have gone.
They've already gone. You can't.
Somehow other 370 was there. Somehow other in plan. What is your lordship has passed?
Can't be
Your
there.
lordship will permit me, my lord, in place other judgments, my lord.
कौन
My lord, my lord, in this slide, my lord, regarding immoral trafficking act, my lord, there is no such judgment of this honorable court. Other high courts of this country, they have stated that immoral trafficking act is not attractive to customers. So in this light, I am submitting also few judgments to your lordship.
So give it a highlight those persons. Yes.
In fact,
yes.
that question which your lordship did, that was our first judgment of our right.
Yes. Yes.
Great.
Item 4. Yes. 4.
I will inform Hon'Ble Court that the Lord State Council, my younger brother, told me that he has called for two aspects report information, that is criminal accident
Yeah,
and also
custody
the
certificate.
custody period.
Yes.
So far the criminal accident is concerned, he has received. But he requested me that he will receive
Pass over from something.
What else? He has requested.
So I already requested. Already requested.
So I'll list it on second September.
in ARC will.
अच्छा ठीक है पास हो पास हो Item 5.
Surrender certificate. The petitioner is a MCL employee.
A period of 2 months.
Conviction is 5 years. Out of 5 years, he is in custody 8 months, 15 days. Due to civil dispute, the case has been stood in PW1, victim has admitted. And since petitioner is a MCL employee, and he has been called upon by the employer, even if not joined today, he will be dismissed from service. And in right time, pursuant to interim order granted by this way, surrendered in right time.
What is this order?
I mean, pardon.
What is this order?
Order showing that the petition has surrendered in time. On 25/2000, he has been granted bail, and he has surrendered on 27/2000.
Interim bail granted by this court for 2 months. You have surrendered.
And on 20th, last order.
Now you have to satisfy me whether you are entitled to bail or not. What is the sentence?
Pardon. On 20th July 2026, he has been.
All right, but what is the sentence?
Sentence is 5 years.
5 years.
And to pay fine of rupees 10,000.
Yes, first you satisfy me. And 8 POCSO is also there.
Madam, 6 books.
The notice has to go.
The notice has gone.
Who is appealing?
Madam, pardon. Notice has gone and the
Service is complete or not?
Madam,
Whether he will be losing job and all these things are immaterial. For I have to see the record and you are entitled to bail.
Madam, main application is pending and the my lord has kept it to 17/9/2020.
Yes.
And the simultaneously my lord has issued notice to the victim.
Notice has been issued, my
My
lord.
lord.
Service. What is
Yes, madam.
service is so.
And the PW wants evidence that the
If you are convicted,
madam,
you may lose the job.
that is true. But the cross examination
And you are convicted for offense under POCSO.
my lord,
Is it a ground for grant of bail?
I leave it where is
Period of custody is only how much? 3 years, 3 months.
No, my lord. 8 months, 15 days.
8 months.
But I may pardon, my lord. PW wants victim's evidence.
Let us see.
PW
If you are entitled to bail, I will grant regular bail.
Para 3.
Yes, 1 minute.
And there was a land dispute. Due to land dispute, yes.
1 minute. Let us go.
Madam.
Yes. 3.
Para 3.
PW?
PW 1, para 3.
PW 1, para. Let us see. Now first, let us see what have you done.
Madam, I may pardon.
What have you done? Let us see. All the questions.
Well, the
My house.
354 allegations, but the trial court has not convicted under 354 since she has convicted under section 8 of POCSO.
And completely get the solve is by last one. ठीक है. And para 3, huh?
Para 3.
Para 3, let us see.
There were land dispute.
Where is that?
Serial,
Yes.
outline.
My
There
father.
were land dispute between Khetros and my father. My father told me to report regarding the land dispute. As instructed by my father and police, I wrote a report. I see the accused today in the court. I have not gone to any TI parade conducted by Mr. I have not been examined by the police. I do not the name of this guy. I have also received injury on my person prior to the officer. on my shoulder.
Show me,
As per the instruction
show me
police-
doctor. Who is doctor? PW?
My lord, P.4 is the doctor.
No.
What is the injuries now?
See, there is injury in the breast.
Yes.
What she is saying in the, just see the para 1 of the victim's statement. He assaulted me.
Item 6. And I may pardon interim bail for.
Sir, you already surrendered.
For duty and.
You have already surrendered what to interim bail.
My lord,
If you would not have surrendered, I would have extended it. Since you have surrendered, then
surrender because
then
due to show my bona fideness, I have surrendered.
that's good. That's good. That may be.
I
that-
played
that-
2
that-
weeks so.
Huh?
2 weeks. 2 weeks. That's 2 weeks so that I have.
You have already surrendered.
And it will grant me 2 weeks so that I will join in the job. Then I will final year. So I pray for
See,
2 weeks only.
We'll see. Tuesday, I may grant you regular bail. Wait.
Okay.
Yes.
Item 6.
Meet visual receipt. Remember the appellant has been convicted on section 13(2), the 13(1)(d) and 7 of the PC Act. Sentence to arrive for 4 years and pay fine of rupees.
Only
Is
for
it-
consideration of bail. I may be pardoned, my lord. I am appearing through VC. For consideration of bail, he is in custody since the date of judgment 3/7/2026.
During trial also, he remained for
He was on bail. I
months.
have given the instruction.
About
Point
months.
number 4. Point number 4. All name may be reflected in the cause list, my lord.
Yes. During the trial, the appellant remained in custody from 14 to 2017 to 2027. And after the judgment was pronounced on 3rd July 2023, prisoner is taken to custody, remain without admitting to the limits of the case, regarding to measure for period of custody since the appeal is up for which year? Appeal is up to 2026. There is no scope of the appeal being heard in the near future. Yes.
Of late, madam.
My appearance may kindly be reflected in the cause list, my lord.
Yes.
Item 8.
Item 7 में इंटीरियर और इंटीरियर में कंटिन्यू मैडम item 7
Yes, sir. Entry mark. Now, what happened to this matter?
Mentioned in the morning.
Okay. When do you want? Seventh you seventh.
Item 8.
Made. And this is order of cognizance taken on a protest petition.
Yes.
I am a body corporate member, I am a company. In order, in connection with setting up my industries,
Who is
thermal power, that is a thermal
for
power plant.
opposite party number 2 who is appearing?
My lord, I'm appearing through VCL also.
Yes, my lord.
Yes, you are appearing, Mr. Saurabh? Yes. Yes.
And your lordship will see that the one case Spectrum Private Limited, no, that is opposite party number 2.
3.
Was interested with the construction work by the petitioner's company.
Yes.
Case Spectrum Limited in turn purchase certain cement this, that, whatever is necessary.
Yes.
From the complainant. Bills were raised against cases was paying.
Hmm.
And whatever bill cases was used to raise, I used to pay. So there was no privity of contract in between me or complainant at any point of time.
Yes.
That would be demonstrated from the complaint petition itself.
Please.
So what happened in this case? Initially, a petition FIR was filed. Then we came before the magistrate seeking a direction on 156.3. 156.3 direction was given. Matter was inquired into. Then the police submitted a final report stating that it is a nature of a civil dispute for realization of money and no criminality can be attributed. Then nothing happened for 7 years. After 7 years, a protest petition was
Fine.
filed. And the court.
Let us see the cognizance order first.
First, let me place that
The
protest petition.
yes. Page.
That is page 125. It begins now.
125. Let us see.
Yes. Paragraph 4. May I draw it? Page 126.
One.
Annexure 11. Page
Annexure?
1 to 6.
Annexure
11. Paragraph 4.
1. 11. 11 is 1 second. This would be 126.
I have also got it.
This would be 126. Yes, 126. Yes. Let us see. Para? Which para you are looking?
Paragraph 3. That Jindal India Thermal Power Limited, now the name has been changed.
Yes.
But I have filed a petition.
Has entered into a memorandum of
I
understanding.
had to correct in that. In short, JITPL has entered into a memorandum of understanding with the government of Odisha, dated such and such, to develop a 1000 megawatt coal-based thermal power at Derang district, Hon'Ble, Odisha. For construction of the mega power plant, JTPL had entered into a contract with Petron's Engineering Private Limited, which stood amalgamated with Castroy Service Infrastructure India Private Limited by an order of the Honorable High Court of Bombay in company scheme such under. Castroy Service Infrastructure Limited changed its name to KSS Petron, and to whom the order was placed.
Yes.
And the change has been duly with the register of company. That as a matter of fact, although KPPL was entrusted with the construction work by JITPL, as I also got that.
Yes.
But in terms of the MU dated 26/9/2006 with the government of Odisha, JITPL having agreed to facilitate participation of local small and medium enterprise within the state for providing products and service required for the project during construction and implementation, as well as operational phases, had the services of the petitioner and other for various purposes by providing purchasers making the execute agreement with KPPL.
KPPL.
Has your lordship got it?
Yes.
The work orders were issued in favor of the complainant by
KPPL.
KPPL, with a clear knowledge and understanding with JTPL. That material against which the purchase orders were placed by KPPL were duly received by JITPL and utilized towards the construction work within the project site of JITPL. Though all the materials as required by JITPL has been supplied and invoices raised from time to time by the petitioner, but for reasons best known to JITPL and KPPL, an admitted due of 31 lakhs 52,000 was left on
unpaid.
petitioner. Your lordship will see that it is
And
not,
it's basically recovery of that amount.
it is basically recovery of that. Issue with both the companies, but each of them shifted the burden on the other for payment of its dues. That the petitioner being cheated of its legitimate
Yes,
dues.
Yes, Mr. Saurabh. This is basically a contractual understanding where some due is to be recovered.
My lord, just because.
Can you resort to criminal jurisprudence for that?
Correct, your lordships. Yes, I can.
And that too after 7 years you file protest petition and cognizance has been taken.
Correct, my lords.
This is one thing. What is the privy between you and the present petitioner?
Petitioner.
Petitioner is you are
That is not contractual.
Jindal. Who is the Jindal? You are only Jindal. Now all of them.
Jindal and the
Okay.
finance director.
Puneet Gupta.
I am
Puneet-
Jindal and its director, my lord. Your lordship knows from the decisions of that R.
Yes.
Kalyani and others that if you have never interacted.
No, if at all, you can do whatever you want to do with KSS, Petron, but what is Jindal's role here?
Correct, your lordship. That, your lordship, is in the protest petition itself.
Yes,
My lord,
and it appears to be a recovery proceeding.
my lord, two aspects to that. My answer, one is.
By the way, have you resorted to any proceeding for the purpose of recovery of that money?
No, your lordship.
Take that.
To the best of my-
Is there any arbitration clause?
Without
There is an arbitration clause for a contract which is not with me, your lordships. And it's
fact,
note,
best, my lord.
Yes.
My lord, that KPPL or
KSS, Petron.
went bankrupt. My lord. That was a proceeding before the company tribunal. NCL. Then for realization of the money where the complainant filed a petition. Then
thereafter an arbitration.
thereafter there was an arbitration in between them. I have also
And there is a settlement also.
in the arbitration there was a settlement and I filed that settlement.
Arbitration between the complainant and that is KSS.
Yes, sir. Your lordship is 122.
Hmm. 22.
100.
It is
100. Sir, 120.
107, my learned senator is probably referring to.
107. Yes. Yes, that is 117. Before arbitration tribunal.
Yes.
Joint application under section 32,
Yeah.
30 subclause 2, subsection
Yes.
2 of arbitration and
Statement annexure A1 dated 13/9/2021. Whatever. Sir.
My lord, my answer to your lordship's queries.
Uh,
My lord, if each senator is completed, can I answer to your lordship's queries?
It starts with some 108.
The paginations are very
Confusion. And I am also. I should have been better conversation and instead of.
108 settlement agreement
Yes, sir.
between Jindal and
KSS Petrol.
KSS.
Whereas the owner has issued a contract number such and such, whereas during the injunction of the website, whereas the party filed the respective plans. Whereas during the pendency of the arbitration proceeding, parties discussed for an amicable settlement pursuant to which the arbitration proceedings were adjourned by the London Tribunal signed a order dated 3/7/2000 for reporting on the settlement. Now, therefore, the settlement of agreement is made between the parties for valuable mutual consideration and witness of
112 page.
112, para 4.
Yes,
Has your lordship got?
the contractor confirmed.
Confirms and undertakes that claim, if any, is made by any statutory authorities or by any subcontractor, supplier, vendor, workers, or any other agency at any point before or after the settlement agreement in respect of works awarded to the contractor for the project, it shall be the sole responsibility of contractor to deal with and settle such claims on its own without any recourse to the first party, that is me. In accordance with the provisions of the Insolvency and Bankruptcy Code 2016 or any other relevant law, and owner shall not be liable for any such claims in any manner.
So,
They have then after that a joint petition, as I was showing to your lordship.
Yes,
Joint application under section that is
that is
remand
117.
invoked arbitration agreement against the respondent by notice dated as such under clause 27 general conditions. And that is why you will see through Sandeep Bajaj, advocate and solicitor, advocate for the claimant.
Yes.
And that's got it. Then you will see the order of the cognizance.
Yes.
At the last
133.
133.
Yes, 133.
The order dated 16/8/2023.
Yes.
The case record is posted today for passing necessary order. The initial statement of the complainant was already recorded on 200 of the CRPP. One witness, namely Suresh Kumar Saha, has been examined on behalf of the complainant in 202 CRPC inquiries. Reviewed the complaint petition and the documents provided by the complaint. Initial deposition of witnesses for the side of complaint. I am of the prima facie. Materials are available on record for the offences punishable with hence cognizance of there is sufficient to proceed against the accused person, namely cases Petra, Mr. Sanjeev, against the accused person, namely case by represented through its director, Mr. Sanjeev Khanna, Sanjeev Mehta, case Petra. Then we lot 4 Jindal India Thermal Power Limited, represented through its director.
What about the other accused? They have the challenge?
Punit Gupta.
The other accused have not challenged.
We don't have any information. I don't have a grievance so that the other accused being proceeded with.
No, whether they have challenged it or not.
I'm not planning.
I don't have any information, madam.
Yeah, that's a stamp report point out.
Now, what about is there any stay operating?
Yes, sir.
Yes, there is still.
Now, in this context now, but since a protest petition was filed in after 7 years now,
Yes.
and this arises out of a protest petition now, I will give you a copy. So find it not true.
Yes. Further proceeding is stayed.
Yes, there is stay order is there.
Yes, stay. Yes.
That is reported in 2000.
Yes, Mr. Saurabh.
One Maharashtra law.
Are you ready?
Yes, Your Lordship.
You prepare your synopsis, list update and written note of submission, and give both of you give.
Lord, I have to argue, Your Lordships, my Lord.
Sorry?
Lord, I need to argue. I need to just point out 3 things to Your Lordships, my Lord.
Yes, point out.
Lord, I will only take this 2-3 decisions. One regarding scope of 156 and 202 criminal procedure. That is No, much search, visited it is not. 2001, Maharashtra Law Journal. That is in the case of Suhas Balkrishna Desai versus Chandrakanta Ramchandra.
Bombay High Court. It's Bombay
Sorry,
High
my
Court.
lord, giving a Manupatra as well.
Bombay High Court.
Bombay. High Court.
Yes.
If I can have the Manu citation.
Citation, I will give a copy because the citation you may not give.
Right, so I'll collect it from you.
It's a heavy matter. You should have come to the court.
Your Lordship may kindly post it next week, my Lord.
Partly I heard I spent a little time going on. Yes. Yes, which para?
Yes, Your Lordship.
Lord, paragraph 7
Yes.
begins, I don't know who said it.
Ramnan.
However, I am not.
Say, sir.
Paragraph 7.
Page.
However, I am not, for the reasons stated hereunder, going to the facts of the case much in detail, because it is a matter again for the magistrate to examine. But I have to state that the magistrate ought to have, when he disagrees with the police, stated the reasons as to how he does disagree with the police and on what materials. This is so because the judicial authority is bound to act in conformity with the principle of natural justice and fairness. The responsibility of the magistrate is so high when he disagrees with the police, which report says that no offense is made out. In that circumstances, a wholesome statement that he doesn't agree with the police report is not sufficient in compliance with the principle of justice. That part is also not there here. With the principle of natural justice, magistrate should have at least indicated in the order on what material has placed reliance for taking cognizance of the offense. Taking cognizance of the offense is a serious matter. By doing so, the court is implicating a citizen to an offense and asks him to face the trial of the offense, which affects his rights and reputation. Therefore, the accused is entitled to know particularly when the police say that he cannot be implicated, on what ground he should be implicated. On perusal of the record, I find that the magistrate has directed the police on inquiry under section 103 criminal procedure code. It implies that he is not prima facie satisfied with the allegation contained in the complaint.
He has to give reasonings.
Yes.
That's what it says.
Yes. So
particularly when it arises of 156(3) and the police investigate, file a closure report, and thereafter a protestation is filed belatedly after 7 years and all.
Yes.
So therefore the reasons should have been there, where reasoning is lacking in.
Then we will accept very old decision of justice. DP Mahapatra.
And if both of you agree, I will set aside and send it back to the trial court for fresh consideration. This ground is enough for getting it.
Kindly see that he himself admits
that is on merits.
That he says he himself admits that unpaid dues. That means dues was some dues were paid. For balance, he is claiming against depreciation. So it is, of course, so in merit also, that the ingredients of 406, 420, right from inducement.
That's a different taste altogether.
Your Lordship, I kindly see this SW, Palantkar and others versus state of the art and no police.
Para?
Like 4 and 5, that there was an agreement. Then your Lordship, 22 onwards, as your lordship got it.
Yes.
It is clear from the allegations made in the complaint and his own statement that the applicant number one company entered into an agreement with the respondent number two on certain terms and conditions. It is alleged that the applicant number 7 went to Patna and contacted them. Then facts, looking to the complaint and the grievance made by the complainant therein, and having regard to the agreement, it is clear that dispute arises out of the said yard. Clause 29 provides for reference to the arbitrator. Complainant issued a notice dated such and such for his redressal for recovery of by way of.
Para 24 is important, many a time.
Many a times, complaints are filed under section 2 by parties with an oblique motive or for collateral purpose to harass, to rape vigilance, to pressurize the actor to bring them to their own turn, or to enforce the obligation arising out of breach of contract touching commercial expenditure. Instead of approaching civil court with a view to realize the money at the end. Then we are similar. Another decision of the High Court of Hon'Ble was Krishnan Desai and others versus Chandrakant Chasudan. They are the copy to copy.
In the earlier judgment which you were relying upon, this judgment,
Yes.
so this one, Palantikar, para 28, just see.
Yes.
Para 28. The earlier judgment. The one which you read. Read para. Just previous judgment.
Paragraph 20.
28.
Okay, we have already stated about the except the applicant no offense was made in the remaining applicant.
No, para 28.
28. Yes, sir.
In the case in there.
We have already stated about that except against the appellant number 7, no offense was made out against the remaining appellants as the ingredients of offences alleged against them were not satisfied. Unfortunately, High Court felt to is correct manifest error committed by the issuing process against the appellant 1 to 6. And when the alleged act against them didn't constitute for want of satisfying the ingredient. The prior to that, that is
it just gives the scope of interference in 482 in
Yes.
in these kind of cases where
Yes.
it is arising out of 200
prior to
proceedings.
that you have not seen any issue. It says that ingredient of the offense of 420 and
Now, in that para 28 only you would see this being the position, exercise of 482 should be consistent with the scope and ambit of the same in the light of the decision aforementioned. The appropriate case to prevent the judicial process from being an instrument of oppression or harassment in the hands of the frustrated and vindicative litigants. Exercise for inherent power is not only desirable but necessary also, so that the judicial forum of the court may not be allowed to be utilized for oblique motive, and the person approaches the High Court under 482 to cause very issue of the process, as the High Court on the facts and circumstances of the case has to be exercised the power of the
Then you have to see the paragraph 11 of that judgment.
Yes.
The ingredients and offense of that should be a fraudulent or degenerance in the spirit of person by deceiving him. 2A, the person so deceived should be induced to deliver any property to any person or to consent that any person has taken any property. person so deceived should be intentionally induced to do or omit to do anything which you will not do or omit if you are not so deceived. The act of should be one which causes or likely to cause damage in the body, mind, and reputation. One of us, then that's has been
This is
several
not about the
days.
judgment. Yes.
It says, paragraph 21, turning to the facts of the case, there is nothing either in complaint or in the sworn statement of the complainant and three witnesses that any property was entrusted to any of the appellants at all. That is from 4 onwards. I'm not. 1, 2, 3 are KPS.
This judgment is clear. Yes.
Domain
Next,
over
any other judgment you want?
to satisfy the.
Any other judgment? Any other judgment you are relying?
Several judgment. Right from.
Highlight those judgment and give.
Lordship.
These are the issues.
Lordship.
Yes, Mr. Saurabh, what do you want?
My lord, will your lordships hear me in person, my lord? Any date your lordships give?
No, you have spent little time now. Just tell me.
I'll have to go through the judgments of my learned senior, so I was wanting to give one rebuttal at one time, my lords. I just the citations I can point out to the aspects in my judgments.
Monday,
but
you come on Monday. Come on Monday. Come on Monday.
Your lordship,
And you prepare a written note of submission, compilation, and
Lordship.
partly heard. Partly heard. Yes.
my lord, may I request my learned senior to the judgments?
Yes, judgment, whatever you are relying, give it.
I will give it.
And you come with a written note of submission. I will only give 10 minutes. I have understood.
Lordship. Obligation.
Try to convince your lordships within that time.
Come with written note of submission. Yes.
I will.
Item 9.
Lord, the state has taken time during the course of further hearing, Lord. Here, my Lord, no, the mandatory provisions of the NDPS Act are given. Oh, Lord, my Lord. Like 42, 52, 50, and 59, all the mandatory sections is not Lord. Here, my Lord, case of the prosecution is that offending vehicle is a Innova car, and some contraband article has been recovered. So, for observation of Lordship's judgment, the Innova car is not a public place, Lord. And while the informant who is in police station received an information, that's why section 42 is to observe highly, my lord, by the prosecution.
This you have already argued.
Yes,
Why
yes,
again it is restated?
my lord. But state has taken time. Sir.
Yes.
Only point that the non-production of stationery will vitiate the trial or not. If non-compliance in entirety is something otherwise. Here is the how his non-production is prejudice caused to him. Otherwise, if the prosecution proves and establishes that commission of crime has been committed by the present appellant, then he cannot take solely in
No, but
advantage.
in the NDPS, there is no question of prejudice or no prejudice. Have you complied or not complied?
And also there also that prejudice is another thing. If something has
Now,
not
suppose you have not complied, and then can you
No,
argue that it is not prejudicing, therefore I will not comply?
My submission, madam. Not compliance in fully, compliance in part. There are two things. He has information received in the police station, reduced in writing. They are not disputed and reduced. Only non-production station right.
Can it be said to be compliance?
So for the Shabilal Bansar case, our own I got.
Yes.
I'll just examine in my written note. There it has said that if non-so exhibit the station diary, not vitiate the entirely. If otherwise the prosecution is approved and established the commission of offence.
You have a judgment.
No, I'll read it or not. I'll.
Mirror only, and the last occurrence also my senior has detected the Colonel Singh judgment, my lord. Only page 12, my lord. Just have a class the page 12 I am reading, my lord. It is there. Near.
Yes, page 12.
Page 12, my lord.
Para?
para that is 17, but relevant is 17B, my lord.
Yes, but if the information.
But if the information was received when the officer was not in the police station, but while is on move there on patrol duty otherwise, either by mobile phone or other means, and the information call for immediate action, and any delay would have resulted in the goods for evidence being removed or destroyed, it would not feasible to practical to take down writing the information given to him. In a such situation, he could take action as per A and D of the section 42(1). And thereafter, as soon as it practical, record the information in writing, forthwith the information same to the official, my lord. Then my lord, see, in the other
If he is in move,
my lord,
in a patrolling duty is
my lord,
doing and got a information, he doesn't have the time to.
my lord.
So
Right, after that,
he coming, I'll come back and.
yes, that 42.
But here, what the fact is, he was there in the police station when he got the information.
My lord.
So he could have written.
Say offending vehicle, that offending vehicle is not a public place, my lord. Not a public.
You complete this, thereafter you go to offending vehicle.
Yes, my lord.
Complete this judgment.
My lord.
Why you are jumping immediately?
No, my lord. Then my lord, see, in other words, the compliance with the requirement section 42(1) and 42(2) in regard to writing down the information received and sending a copy thereof to the superior officer should normally precede the entry, search and seizure by the officer, but the special circumstance involving emergent situation, the recording of information in writing and sending a copy thereof to the official superior may got postponed by a reasonable period. That is after the search, entry, seizure. The question is one urgency and expediency, my lord. But here in this case, my lord, say police station, while the informant is in police station, my lord, at the time of he got the information.
But it has to be done.
My lord, he has to be done.
Yes.
For that reason.
The total non-compliance.
While total non-compliance of requirement of subsection 1 and 2 of subsection 42 is impermissible, delayed compliance with satisfactory explanation about the delay will be acceptable compliance of section 42. Here, my lord, partially also not compliant.
To illustrate, look,
My lord.
to
illustrate, if any delay may result the cause escaping the goods of evidence being destroyed or removed, not recording in writing the information received before initiation action, or non-sending a copy of such information to the official superior forthwith, may not be treated violation of section 42. But if the information was received when the police officer was in the police station, here my lord, officer informant is in the police station, with sufficient time to take action.
And if the
police officer fails to record in writing the information received or fails to send a copy of therefore to the official superior, then it will be suspicious circumstance being a clear violation of section 42 of the Act.
But here in this case, entry was made, but that entry was not
proved.
Intimation was also superior immediately.
To buy over phone.
Over phone, so no phone.
But the phone number is also not given. Similarly, where the police officer does not record.
Where the police officer does not record the information at all and does not inform the official superior at all, then also it will be clear violation of section 42 of the Act. Whether there is adequate or substantial compliance with the section 42 or not in a question of fact to be decided in each case. The above position got strengthened with the amendment section 42 of the Act 19/2001.
But there is a concept of substantial compliance also.
No, my lord. See, the extract diary ta khali only special diary entry name. Special diary.
What is substantial compliance?
Substantial compliance means
in your case, what had happened is there is a diary entry.
Diary entry.
No doubt about it.
Yes, sir.
And diary entry number is also there.
Diary entry number is also there. But what is the diary entry number? If he is stated
and that diary, the extract of diary entry is not placed on.
Not placed, my lord. And that extract diary has not sent to the official superior. And from the official superior, nothing has been seized to compliance. My lord, that has been not done.
So it
SP
can,
also
it
not.
Can't, therefore, you are according to you, it can't be even stated to be a substantial compliance.
No, my lord.
Full compliance, substantial compliance. They may argue it is a substantial compliance, but according to you, it is.
Yes, my lord.
No compliance.
Non-compliant.
No compliance.
Not non-compliant.
Yes. Yes.
Then, my lord, another judgment, my lord, that is
Yes. Gadwa Mudli.
judgment, Ghadwa Mudli, my lord. In Ghadwa Mudli, it is also observed that
Which para?
the sections must be followed, my lord.
Para?
ସେଟା ଆପଣଙ୍କୁ ଦେଇଦେଲି କି?
କଣଟା?
ସବୁ ଯାକ ମୋ କପିଟା ଗୋଟେ ଦେଇଦେଇଥିବେ ବୋଧେ। ଟିକେ ଦେଇଦେଲି ବୋଧେ। ସବୁ ଯାକ ଟିକେ ଦେଇଦେଲି। ଆଜ୍ଞା ହଁ। In Ghadwa Mudli, that is page 7, my lord.
It also takes notes of for this.
Page 7, Ghadwa Mudli.
Para?
Para, that is continuing from the lengthy para 5, my lord, but para 7, middle part, my lord. There is a D पर 2 ଅଛି। para 7, my lord.
full page ବାହାରିନି।
ଅଛି ନା?
ନା ନା ସେଟା 1 to 12 page।
That page is
only 6ଟା page ବାହାରିଛି।
6ଟା page ମାନେ ଏପଟ ସେପଟ ହେଇଛି ନା ଡିପୋର୍ଟ ପ୍ରିଣ୍ଟ ହେଇଛି।
ଟୋଟାଲ ହଉଛି 12 page 1 to 12
page
ହଁ 12 page
page 7 ର କଥା କହୁଛି।
Page 8. Where is page 8?
ନାଇଁ ପେଜ ନାହିଁ 1 ଅଛି 2 ନାହିଁ 3 ଅଛି 4 ନାହିଁ 5 ଅଛି 6 ନାହିଁ ନାଇଁ ମିସିଂ ପେଜ ଅଛି।
Then my lord, para 7 ଟାକୁ ଦେଇଦେବି ଆଉ ଥରେ ଦେଇଦେବି ସେଟା। I am just reading, my lord.
How many days you will keep on arguing? Good judgment rather cheap.
Yes, my lord. ନାଇଁ ସବୁ ଯାକ ସରିଲା।
This is fourth hearing, it seems.
No, I have concluded. All the sections has not.
And it was judgment was reserved. You mention it to be mentioned ronala. तापर भी judgment आने को अधे अच्छे होते।
आगे नहीं, इतना खाली।
Kind of preparation you. I don't understand. Judgment was already reserved. On your request, I listed it to be mentioned. That day also it was heard. Again it is heard. Issue is so small.
Just I am reading, my lord. But while total non-compliance of requirements of section 1, Ghadwa model reports, and section 2 of this section 42 is impermissible, delay compliance with satisfactory explanation about the delay will be acceptable compliance of section 42. To illustrate, if any delay may result in the accused escaping or goods of or evidence being destroyed or removed, not recording in writing the information received before initiating action, non-sending a copy of such information to the official superior forthwith may not be treated as violation of section 42, but if the information was received when the police officer was in the police station with sufficient time to take action, and if the police officer fails to record in writing information received or fails to send a copy thereof to the official superior, then it will be suspicious circumstance being a clear violation of section 42. This is the observation of Ghadwa Mudli, Lord. And Ghadwa Mudli also Lordships observed in Santosh Singh case, Lord.
Jagraj Singh, para 12 justice. Para 12 and 13.
Para 12 of the judge. How do
No, Jagraj Singh.
Jagraj Hansa, yes. Below.
Yes, you give your judgment. Whatever. Yes. Yes. You want to give
Fully and substantial
Written
and not
notice.
fully compliance, not these are the two.
substantial compliance
Substantial
and complete non-compliance.
Search seizure notice. These are three
No,
minimum.
but see, that Rajasthan judgment, which says that entry was made and but wrong entry was communicated. Then the court says that it is not
Fully compliance.
not compliant. Here the entry is made, not at all communicated.
And intimated to superior, but station diary was not exhibit.
That station diary, that exactly that situation is
But
covered
that will
in the Rajasthan judgment.
that will be read in consonance with the order of the learned SDGM. Then it cannot be doubt that there is no source seizure on the production of the material or the very part.
That's there, but only that part.
That part.
If you the extract of the station diary is not exhibited, not proved on record, whether it will
Not
be
fatal.
treated as treated to be non-compliance of 42 to 1 or not, or it can be
Or-
said to be substantial.
Or it is fatal to the.
That's the only point.
Yes.
Yes.
I have given the notes of argument.
Yes.
Already given.
Yes, you also give it.
I will. I was prepared, but because of to be mentioned again, I will.
The copy of notes of argument copy also I have submitted.
Password item 4.
Who aspect my parent will summarize regarding custodial video. And for the
3 years, 7 months, 25 days.
again, how much to them?
Good conduct. Yes. Pursuant to the order dated 3/8/2026, the jail superintendent, DC jail superintendent Mayalander has placed a report dated 28 after the publishing. Indicating that the appellant has already undergone 3 years, 7 months, 25 days here on Kudiyatro, publishing. And the jail conduct is also taken to the satisfactory. Yes. Report is taken on that. Yes. Yes. What is the sentence?
6 years.
6 years? 3 years? How much here? 3 years?
3 years, 7 months.
Yes, but 3 years, 7 months. Out of 6. Out of 6 years. And this is an appeal of 2025. There is no chance of hearing.
As well also.
Without advertising such a case, and since the appellant has already undergone more than 6 years sentence, more than half of the sentence avoided. That is 3 years, 7 months from out of a total avoided sentence 6 years. And since the appeal is up to 2025.
No. Fine is that.
Appeal is up to the year 2025, and there is no likelihood of the appeal being heard in the near future. I'm inclined to suspend the sentence. Fine. Realization of fine. You have an application for that?
771.
Yeah.
771.
Yes. Yes. Mr. Dhal, which matter you are waiting for?
A small case is there. Associate will do, then 2 other cases are.
Then after 12 o'clock, I'll hear it. After 12 o'clock, I'll
It's
see.
a small matter.
Small matter. Yes. Four. Huh? It's all right. You were 66 years in 2007.
But out of our instruction is there are 6 appellants before your lordship,
Hmm.
and out of them 5 and 6 are obligated.
5 and 6.
5 and 6.
Okay. 5 and 6 died. Yes. What is the offense?
But they faced trial of 397
At the outset,
and section 3A.
the outset, the Learned Council appearing for the appellant submits that the appellant number 5 and 6 has the previous segment. Appellant number 5 and 6 from this file. Yes. Yes.
Based trial 397
File the
with 34.
397.
397 with 34 and section EA of Odisha Electricity Line Welfare Unlawful Possession Act 1980. Out of that, under 397, they got a acquittal from there because there is no evidence, and 2 years conviction under the Electricity Act and 1,000 rupees fine. And there are 13 witnesses have been examined. The case of the prosecution is that on 19/5/1990, they got a information that some of the culprits were stealing the pipes and wires of the in a jungle.
File is not there. Yes.
We got a information that some of the culprits were stealing 11 kV lines from the jungle. The police personnel and some of the witnesses went to the spot and
May
found that some.
pardon to submit, my lord. The instruction was sought for. That has not come. I prefer next week only.
No, because that is also I was just wondering because 2 of the appellant have died and the other appellant are senior to them.
Okay.
66 years and all of them are, he says that 5 and 6 died. I don't know whether the other people still survives. And this is one thing. Second is they have been acquitted under 379.
397.
397, sorry, 397. And what else remained?
Whatever my observation there that there can be compoundable other things because the electricity there is this.
Electricity Act, is there any bar?
Special Act is a bar.
Huh?
Special Act is a bar.
No. The Act itself, Special Act, all the Special Acts are not barred for provision. Is there any bar? Is there any bar? Have you seen it for probation? Who is the you have been convicted for which violation of which section? 3? Orissa electricity supply material.
Orissa electricity supply line.
Orissa electricity, no? Orissa electricity supply and material unlawful possession act. Supply and material. Where is that provision is not there condition?
Under section 3, there is no penal provision.
There is no penal provision.
No penal provision or violation of any.
Where is that act? Do you have that act?
No, that means.
Then what is the sentence then?
Years,
2 years.
years and 1,000 rupees fine.
He says no penal provision, penalty is there.
It's there.
Section 3 of
Section 3A.
prescribes punishment for the offence under clause A and B punishable as per the penal section. Lesser punishment for the first and admittedly there is a committed similar offence. I have to be in case so this condition. इसको सेट करो. Section 3A.
A and B.
3A. It's not the provision. Do you have that books with you? Not there. Next week. Next week. Okay. Next week. Get the report. Huh?
Yeah.
And get the provision. Because it says for first time offender, this is the penalty, second time offender and all. It seems you are the first time offender, so therefore 2 years.
Higher punishment, suggestion of enactment. There is nothing record shows the first offender.
First offender.
No previous conviction is there.
এটা भी चोरी ही थी वो.
से लाइन को जो कटिगला रात्रि से मैंने कंप्लेन गला वेरीफाई गला फाउंड दैट दिस पर्सन्स आर इन्वॉल्वड इन थेफ्ट ऑफ द इलेक्ट्रिक मटेरियल्स थेफ्ट 11 kg theft.
But they have been acquitted. Charges of theft.
But possession, the 394 is acquitted, but possession of the unlawful possession of the electric material.
Concern you will not see. We don't have any possession. We are in a G. The line, the bundles were scattered in the jungle.
It's not recorded from you.
Not recorded from. Lots of kinds PW IO statement.
Who is IO? PW?
PW 30. On 18/9/99, I was posted to OIC Moranpur Police Station. Night Friday, I was performing petrolity at the Korea cross-crossing with my staff. I got confidential report that some unknown culprits were committing theft of aluminium ware from 11 km in Korea forest. I proceeded to the spot with my staff, with some villagers at Kalakada. Conducted raids in the said forest. During the raid, I found that a span of aluminium were stolen and kept in 4 bundles. One span was lying in scattered manner. I have seen the aforesaid 4 bundles of aluminium were lying scattered in the presence of witnesses. I prepared the seizure list, exhibit 2 is the so in my presence. I surrounded the forest and made search of the and found one jeep bearing so and so kept in there. 6 persons were inside the jeep. On verification of the jeep, I found 3 hacksaw, idle cutters, 2 big roll and small pieces of aluminum conductor inside the jeep.
It was not recovered from their position.
Para 4 mechanism. They have then below that they have also pelted the stone on the police officer.
No, that was disbelieved.
I visited the
That
spot
was
and they
disbelieved
kept-
and because of that, they got an acquittal
arrested.
from the 397.
During there, they pelted stone as witness Prabhakar Mandi sustained injury and their person took welfare as one. Then para 4. I visited the spot and examined the witnesses same night and arrested the accused person SK Sadiruddin, Buddha Das, Ramchandra, Dr. Hussain Sassan. I sent the injured witness to the medical examiner police. They have
No, all these things are there, but possession, for possession, what is the evidence?
that point that jeep.
Nothing was recovered from jeep.
PW1 is the seizure.
The wires and all were scattered, it was lying scattered in the jungle, and these people are there just nearby that place in that jeep.
Inside.
Whether it could be stated to be possession.
Must be actual
Actual physical position. It's not
sitting nearby.
nearby in jungle. We don't know why they went.
That is
Why they went.
that the jeep belongs to whom? That is if that evidence.
Let the jeep belongs to the accused person. How does it make it?
2 years.
Unless you connect that. Unless you connect them with the seized article, the wire.
Materials.
And particularly once charges of theft, they have been acquitted. चोरी कला पर तो पोजीशन नहीं थी चोरी कले तापर पोजीशन चोरी प्रूव हेलानी पोजीशन कोड आस्ता
ତାର କେବଳ ସିଜ୍ ବେଳେ ଯାହା ରେଡ୍ ବେଳେ ଧରା ପଡିବ ସେତିକି ଆଉ ଅଦରେ
ଏଭ୍ରିଥିଂ ଇଜ ଅଲ୍ ରାଇଟ୍ ଚୋରି ଆପଣ ଏକ୍ୱିଟାଲ ହେଇଗଲା ଆପଣ କରିଦେଲେ ଚୋରି କରିନାହାନ୍ତି ବୋଲେ ୱାଇର ଗଲା କୋଉଠି ତାଙ୍କୁ ତାର ପୋଜିସନ ବି ତାଙ୍କର ଫିଜିକାଲ ପୋଜିସନ ରିକଭରି ହେଇନି ଇଟ୍ ୱାଜ ଲାଇଂ ସମୱେୟାର ଏଣ୍ଡ ଦିସ୍ ପିପଲ ୱେର ଏଣ୍ଡ ସେ ପାଖ ପାଖରେ ଦେଖିଲାଣି ସେମାନେ
they are standing nearby in the dead of night in the jungle.
jeep ରେ
ପିକନିକ ରେ ଯାଇଥିବେ
ରାତିରେ dead of night picnic there is no
Maybe.
3:30
ବୁଲି ଯାଇଥିବେ how do you know maybe physical they were there that doesn't mean that they are the accused you have to establish
I was there.
how will you establish the case
No.
any eyewitness anyone any eyewitness is there
Jay reading party.
they must be involved there is no doubt but where is the evidence evidence has to be there
Next week I will examine on that.
they are involved there is no doubt about it but unless you have the evidence you can't help it
କଣ କରିଦେନା କାଟି କୁଟି ଦେଇକି ଥୋଇ ଦେଇକି ଏଠି
that you know that
that I have my experience
ସେପଟେ
in my village.
continue ତାପରେ ଧରା ପଡୁଛି
ଯଦି କିଏ ଆସିଲେ ଆସିଲା
ନହେଲେ ଉଠେଇକି ଧରି ଚାଲିଥାନ୍ତେ ସେତେବେଳକୁ ରେଡି ହେଇଯାଇଛି
ହଁ
but some evidence you should have brought
but
they have kept it and all
I will examine and
yes I'll just come
Here, Bernard, it's a case of 498A and 304B, where in 498A,
yes,
conviction is for 2 years. For 4, you DP Act was for a sentence, but with regards to 304B, 10 years.
yes.
Bernard, I was pleased to hear it last occasion. Here, Bernard, just iterating the same, Bernard, to substantiate the allegation, prosecution has examined around 11 witnesses out of which PW1 is the informant, PW2 and 5 are the brothers of the informant. PW8 is the additional Tahsildar cum executive magistrate who has recorded the dying declaration under Exhibit 6. And PW10 and 11, the investigating officer. And the last one is going to PW3, the doctor who conducted postmortem examination. And here, I have developed the point that marriage is disputed because prosecution case is marriage had taken place at Midnapur Sub-Register Court, and the investigating officer who has investigated into the case, PW11, he has categorically stated, in course of investigation,
No, I remember.
had done that, but I could not find anything.
The case for
Subsequently, they developed
the case of suicide.
But a pertinent question was put to Aspirant that whether in the case of 304B, specific allegation of suicide is there, whether 304B is maintainable law.
Yes.
What I feel, my lord, after analyzing good many decisions, 304B is maintainable. But before going,
Just what is running in my mind is, suppose it is a case of 302, specific case of murder. Maybe because this happens within the 7 years of marriage and all, without framing 302, can you frame 304B? If that is true, in case of 306 is also the same, it is true.
well, with regards to this fact, well, I was going through, if, like the other case, which pilot hard, but please to hear me, that if he would have been acquitted from the charge under Section 4 of DPI, demand after the marriage,
yes,
then case of 304B would not have been there.
Yes, that is another argument. Yes.
But because another one judgment I got, that also I have cited on the last occasion in that case, Chhabi Karvakar case. That is a case of 2025 Supreme Court, wherein it has been held like this. It is in the case at hand, at paragraph 15, Honorable Apex Court was pleased to observe. In the case at hand, it has not been proved by the prosecution that the deceased was subjected to cruelty soon before her death in connection with the demand of dowry, and hence we are of the opinion this is not a case of dowry death under 304B IPC. PW1 and 3 had only stated that the deceased used to tell them about her torture. PW4 did not speak about any demand of dowry after marriage. Moreover, this witness had said that appellant number 2 used to assault her deceased daughter as the deceased had objections to the illicit relation of appellant number 2 with another woman. PW16, who is the cousin of the deceased, had deposed in court almost a year after the testimony of PW1, 3 and 4. And in his deposition regarding the physical assault of the deceased in connection with the demand of dowry is also not believable. Considering the aforesaid, in our view, the trial court aided in raising a presumption under 130B.
There, the torture was because of the relationship, extramarital relationship.
Yes.
So it is not a dowry death. Hence 304B is not made out. That's what the court says.
No. Yes.
That's what in this case.
306 ultimately conviction is 306. Here, my lord, prosecution is solely relying upon, my lord, the dying declaration alleged to have been recorded by PW8 under the Exhibit 6.
Yes.
Before going to the dying declaration, my lord, may kindly see the statement of the doctor, PW3.
PW3?
PW3 is at page 66, Dr. Durga Charanam Paji.
Yes.
All the all the internal organs are contact and congested, heart full of blood, it is so and so. The burn injuries are antimortem in nature. Beforehand, manner external third degree burn of face, chest, abdomen, both the thighs, anterior and posterity, both upper limbs, all over back, about 90%. Rigor mortis is over the lower limb. Due to the shock on account of burn injuries, time since death within 24 hours of the postmortem examination. Dr. A. Mishra was also there at the time of conducting the examination. This is that report. Exhibit 3 is my signature, and Exhibit 3/2 is the signature so and so. Ordinarily, a patient inflicted with such type of burn injuries, as noticed at the time of PM examination, would remain unconscious. Though I have not mentioned in my report that the death was due to shock on account of burn injuries, but a person inflicted with such burn injuries ordinarily dies with shock.
Yes.
This is the statement of the doctor examined as PW3. And we see the evidence of PW8.
PW8.
Madam. Then magistrate who has recorded the dying declaration. The injured sustained burn injuries on her body, paragraph 2. Madam.
Just the recording. Yes.
The injured sustained burn injuries on her body and slept on the bed. She was in conscious state and was able to give rational answers. Madam, we can underline it. She stated before me that she was Manish Saspal, wife of Kokon Saspal of village so and so. She had married Kokon Saspal about 3 to 4 months back. After the marriage, she was tortured by her husband and mother-in-law physically as well as mentally for dowry and other reasons. She was assaulted by her husband. When she could not tolerate the sufferings, she herself poured kerosene over her body and set her ablaze by a lamp. After hearing her cry, her husband, who was sleeping by her side, extinguished the fire. Thereafter, she became unconscious. This is the statement of Manish Samal under Exhibit 6. Sub-Collector Varipada, by official correspondence, directed me to record the dying declaration. On the previous day, after receipt of the information from Sub-Collector, I had proceeded to DHS Varipada on 2/9/92, but I could not record her statement as she was unconscious at the time of my visit during the afternoon. On 2/9/92, she was unconscious.
Yes.
I cannot say as to who was the physician in charge of the ward and the particular ward since she had been admitted. I cannot say the name of the ASI at town PS who had accompanied me to the hospital on that day. On 3/9/92 at about 12:45 p.m., when I again proceeded to record her statement, doctor in charge of this treatment of that patient was not present. It will kindly be taken note of, madam. But the staff nurse and other official staffs of the hospitals were present. It is also important, madam. Police officials and the staff nurse who was on duty identified injured Manish Saspal. I have not mentioned in my report as to who identified Manish Saspal before recording her statement. I had not made any efforts to contact the doctor who was treating Manish Saspal. Manish Saspal answered me in Oriya when I put questions to her. Case reported in 2021-60 SCC 158. And let me kindly see.
Yes.
It's a case of 302-498A. Short judgment manifest.
Ramesh Gupta has argued this matter.
Madam.
Ramesh Gupta, senior counsel, is there? Para 10.
Madam.
Para 10.
Each line.
A dying declaration is admissible in the evidence 32. It alone then also with the basis of conviction.
Because the lying declaration sanctity is attached to the.
There is a contradictions, variations, without truthfulness of veracity of declaration respect, the accused is able to create doubt. Yes, the accused is able to create doubt. Not only with regard to the dying declaration, but also with regard to the nature and manner of death and benefit of outcome. First statement of the deceased is based on the hearsay.
And another judgment by that.
What is the ratio?
Ratio is that it is not when doubt is entertained, it cannot be believed. Those entities attached to the dying declaration. It's more descriptive.
The doubt, then the doubt is on account of two things. One is on second when the magistrate went.
Detailed judgment is 99 volume 7 SCC 695 by three judge bench, my lord. It was paragraph 8 by the The question as to whether she was conscious and was in fit mental state to make voluntary disclosure of the incident, Dr. So-and-so, who was attached to Denali Government Hospital, so-and-so, she then sent a requisition to medical magistrate.
If the dying declaration is recorded by the doctor and the doctor says that she was fit, then the situation would be different.
It would have been
when
different.
the magistrate goes, it is obligatory on the part of the magistrate to get a fitness certificate. That's what you. That is how it is.
No, but here, magistrate has recorded. Let me see paragraph 8.
Paragraph
8
of this judgment.
Yes. 99. Whereas Srimati Venkatramana, she then sent a requisition to the magistrate.
Hey, where is which judgment you are reading? This same.
99 volume 7 SCC page 695 at page 8. Yes. L. Lachpana Rao to record the dying declaration on the injured. All that Dr. Vishnupriya Devi has.
Para 8 you are reading?
Madam, the injured was conscious, but she was not deposed. She has not deposed that the injured was in a fit state of mind to make a statement. This thin line of demarcation is very, very important. Doctor was present. That the injured was conscious, but she has not deposed that the injured was in a fit state of mind to make a statement. Doctor stated. It has come on record that Srimati Venkatramana has sustained 90% burn injuries. K. Lachpan Rao, a magistrate who recorded the dying declaration, has made a note in Exhibit P14. The dying declaration, after putting some preliminary questions to the injured, and it reads as, on the basis of answers elicited from the declarant to the above questions, I am satisfied that she is in a fit deposing state of mind to make a declaration. Thereafter, the magistrate proceeded to record the dying declaration. At the end, Dr. K. Vishnupriya Devi has appended a certificate saying patient is conscious while recording the statement. The question that needs to be considered is as to whether the magistrate could have come to a definite conclusion that the injured was in a fit state of mind to make a declaration in the absence of a certificate by the doctor certifying the state of mind that existed before recording the dying declaration. In our opinion, in the absence of a medical certificate that the injured was in a fit state of mind at the time of making the declaration, it would be very much risky to accept the subjective satisfaction of a magistrate who opined that the injured was in a fit state of mind at the time of making declaration. It is a case of circumstantial evidence, and the only circumstances relied upon by the prosecution is the dying declaration. It is true that the medical officer, Dr. K. Vishnupriya Devi, will obtain at the end of dying declaration a certified patient is conscious while recording the statement. It has come on record.
After recording, she gives the certificate. And the court says that no, before recording the magistrate has to be satisfied. Thereafter, recording has to be.
Made it made more clear. It was therefore necessary for the prosecution to prove the dying declaration as being genuine, true, and free from all doubts, and it was recorded when the injured was in a fit state of mind. In our opinion, the certificate appended to the dying declaration at the end of and by Dr. So-and-so did not comply with the requirements in as much as she has failed to certify that the injured was in a fit state of mind at the time of recording the dying declaration. The certificate of the said expert at the end only says patient is conscious while recording the statement. In view of these material omissions, it would not be safe to accept the dying declaration Exhibit 14 as true and genuine as made when the injured was in a fit state of mind from the judgments of the courts below. So here there is no certificate of the doctor. Doctor was not available. He was not called for. The nurse who was there, she has not been examined.
The police officers were there. They have not appended the signature there.
He has also not been examined. That police official.
Those who were present there. And the nurses, those who were there, they were examined?
No.
Nurses were no.
But the parents are examined because
Parents?
they have put the sign.
Oh, the
Parents,
where are you going?
Father has not
We are
spoken
on
about
dying
dying
declaration.
Yes, my lordship.
Father has
See,
not-
what dying declaration is, dying declaration as per this judgment. In this judgment, what has happened is dying declaration was recorded by magistrate. Thereafter, the doctors comes and certify she is in fit condition. The court says that no, before recording of the dying declaration, the magistrate should have been satisfied that she is in fit condition. 90% burn in that case. Here also 90% burn. And in this case, in a case in hand, one day before, that is on second, the magistrate goes, the patient was unconscious. He comes back. And next day on third, she goes. He doesn't bother to ascertain the doctor, and the doctor is not there at all. Who were there?
Staff nurse and
Not staff
parents.
and the police persons and all. And the dying declaration was recorded. There is no certificate thereafter also. And two persons have signed in Bengali. And who are they? Nobody knows. The nurses, the two nurses were present, they have not also signed. The police persons, those who have there, they have also not signed. In this scenario, after this judgment, how do you say that the dying declaration could be
Yes.
believed?
Yes, my lordship.
Yes.
My lordship, recent judgment of Hon'Ble Supreme Court
So-
and also Delhi High Court, but that judgment I have not brought, but I have written in my notes. My
Show me the judgment.
judgment.
Don't argue like this.
My lordship, I'm just reading out the paragraph. I'm just reading out.
Read it.
Just note out. Holds that the dying
Citation.
citation is, my lordship, Muhammad Ayub versus State, and it was decided on 16th April 2026.
Yes.
Holds that the dying declaration can be acted upon without corroboration. The primary effort of the court has to be find out whether the dying declaration is true, and if it is, no question of corroboration arises. However, if the circumstances surrounding the dying declaration are not clear or convincing, the court may look for corroboration to the dying declaration. The court held that although a dying declaration ought to be ideally recorded by a magistrate, if possible, it cannot be said that the dying declaration recorded by a police personnel are inadmissible. For that reason alone, the court at the same time questioned that the issue of the whether a dying declaration recorded by the police is admissible, but be decided after considering the fact and circumstances of each case. It was further held that there is a no format prescribed for recording a dying declaration. And if it is not obligatory and it should be recorded in the question answer
That
form.
goes in a different line
My
altogether.
lordship, here my lordship, it's a way.
In that case, the police has recorded
Yes.
dying declaration. Therefore, a doubt was created. Court says that even police can do it, no problem. There is no problem there.
Yes.
Police can also do it.
But the
Police
last,
can do doctor. The best thing is best person is the doctor. He himself can say that yes, she was bit and she can record a dying declaration.
But-
There is no problem. Here what happened, you have invited magistrate. He goes second. He saw that the patient is unconscious. Comes back. Next day he goes.
and he
Once
recorded
next day he goes, then he should have ascertained from the doctor that she is conscious. He says that I have not seen the doctor. I don't know who is the doctor attending. I have not contacted the doctor. And goes on
It's not an
recording.
empty formality
my
because
lordship, she is in a dying bed.
because the
So
language
the-
of section 32(1), the way it has been constituted till date, till this husband, which has been cited by my learned friend, that sanctity is attached to the dying declaration because it's a version of a person who is dying.
Only to the extent which you are reading, this piece of evidence may not be believed, but it can be used for the purpose of some corroboration.
It requires corroboration.
To that extent, it will help you.
Yes, ma'am. And here the dying declaration has taken.
But that dying declaration cannot be taken as a dying declaration in conformity with 32
That,
because of this judgment.
yes,
Straight away. This judgment.
that I will check.
And that can be, you can use it for other corroborative purpose, whatever. That's a different story altogether. Yes. Sir.
My lord. Then, my lord, the next question comes. My learned friend, in the last occasion, I've drawn my lord's attention to the accused statement of the accused statement recorded under 313 to the question number 8.
Yes.
Question number 8.
Yes, question 8.
And submitted to the effect that question has been put to the effect that she is the wife, and when he has stated Satta, it is to be accepted. Like that, she has also drawn the attention of the court towards three other questions where this has been put like this.
Yes.
Now, question comes up whether the question which has been put under Exhibit A can be taken to be a question put as per the guidelines stipulated by the Apex Court? No. Because time and again, this Honorable Court as well as Apex Court has fixed up the principles, the purport of recording 313 and how it is to be put.
Incriminating evidences
to be put individually.
Individual.
And if 6-7 questions will be clubbed up.
Clubbed together.
And what would be the answer?
That's
Satta Vichar. Like that. And this has been also held by Apex Court in good many cases. My lord, that how a dying declaration is to be recorded.
You are trying to say is in question 8, so many things put together and
it should be clear on an unambiguous. That is the language.
But the question reads the PW, my lordship, independent witness. He has rendered that the.
let him
Yes.
complete.
My lord.
Yes.
I'm coming to that.
But the conviction is not solely based on dying declaration.
Realize solely on the dying.
Let us see the judgment.
If this will go and with regards to marriage, there will be dispute because there are specific case that marriage was solemnized there in the registry office at Bidnapur. Investigating officer who was investigated into the case,
he found nothing.
Nothing. Then they have developed a case their marriage has also taken place at Jagannath Temple. If marriage has taken place at Jagannath Temple also.
No, registration of marriage after solemnization of marriage.
No, first marriage. That is at Bidnapur first.
Thereafter,
Jagannath Temple. Jagannath Temple, when a road record is available, at least a priest should have been examined to say, yes, marriage had taken place, I was there.
But
We are saying so because to bring a case under this ambit of 493-304B, because
marriage is
yes,
true.
I have also admitted that she has died in our house. Mother has said, I have asked my son why she has come. And son says, she is insisting for marriage, but I am not interested to marry at present.
But that may not help you in the sense, even nowadays, live-in relationship are recognized.
The present scenario, it was not there.
They say that 125 is maintainable, everything is maintainable in live-in relationship.
Because
so that
it's a case of 92. Where
those days,
live-in relationship was a dream. No conception of live-in relationship was there.
Record also can be available in 92, my lordship. They are not keeping the record.
No. See what he is trying to distinguish evidentiary value. See, if registration of marriage after solemnization of marriage is a different story. You married went and registered.
That is being drawn because to go
Then
to.
if that would have been a case, then the marriage is the solemnization of marriage, Jagannath Mandir, wherever you have done it. But here is a case in a reverse manner. You say registration of marriage I have done in the registry, the Sub-Registrar Court. Thereafter I came and married in Jagannath temple. Then the primary marriage is the registration of marriage because that is the first instance of marriage. So that is not proved. So therefore the marriage is not proved. That is what his case is.
But in Jagannath temple marriage, we have to.
What is the material?
PW5, my lordship, and the girl is staying with the Kokon, my lordship, in the in-laws house, and independent witnesses.
No, they might be planning to marry. See, marriage has to be proved.
Independent witnesses said that she is the
Madam,
daughter of.
try to appreciate the evidence. You can't draw inferences. You have to show the evidence.
Yes, my lordship.
Inference, you're correct. They were staying together. They might be wife and husband. The lady who has died might have died because she was not getting the status of husband, wife. That may be the reason. She herself says that I burned myself. It may be the reason that these people have promised to marry, brought her, but not marry. So that may be a cause of resentment.
Frustration.
But
So from the record, you have to show that see that is his case. He said that I am not married.
But if so, my lordship, he has not taken the name of the father-in-law. She is only saying that my mother-in-law and my husband has done all this.
She must be saying that I am married. She must be taking herself that I am married. But these people are not recognizing the marriage. That may be the frustration for which he committed suicide. You see in that.
But if your lordship will see the dying declaration,
This is a.
saying that there is a dowry.
Madam, listen, when you argue the matter, don't use if, but, and all. In criminal jurisprudence, no if, no but.
No, I am talking
It should
about
be
dying declaration.
concrete.
Exhibit.
If this have happened, if that has happened, might have happened, who knows? Don't use the expression if. Simply tell me the
off-courting decision.
Because he is teaching his case to that level. You have to match that.
No.
This is the third time we are hearing.
Because last occasion, my senior has asked me regarding the marriage, dispute of the marriage, which I have.
As more time you give, we will make. So you should have prepared more than
Yes, no.
senior. So now you tell me, the marriage is coming under the cloud of doubt. Dying declaration is he has created doubt. And in that scenario, what will you do? And for acquitted.
Well, what I was saying, we should all know it. Of course, the judgment of Hon'Ble Apex Court, 81 Supreme Court 765. Sankar Lal Ghiarsilal Dikit versus State of Maharashtra. They say mysterious is the working of human mind. Hon'Ble Apex Court was pleased to observe mysterious is the working of human mind. Why a person has deposed against X or Y, he only can say.
Yes.
The answer is this. Why he has not, they have not implicated father-in-law. That only they can say. We don't one can say.
No, see, from the sequence of event, what looks like, this girl might have committed suicide because she didn't get the status of wife.
And one of the witnesses stated, husband has tried, but this Kokon husband has tried to rescue her, received burn injuries, and he was also senseless at the spot. Huh? That is there.
No.
Court 9.
No say, but
What do you
PW? Which PW?
Mallet?
Which PW?
Mallet. That is there. Prosecution would make matter.
If you come to just see PW5, come to PW5.
yes, ma'am.
Uncle-in-law. Huh?
Yes, says that the
Read it. I know the accused person. Accused so-and-so is the son-in-law of my younger brother.
The Sadananda,
Daughter of Sadanand was given in marriage with so-and-so about a year back. Okay? The marriage was held. This is very important. The marriage was held before the magistrate marriage officer, Medinapur. Okay?
Yes.
Thereafter,
It
was also celebrated in temple, Jagannath temple in Medinapur.
Yes.
So that first part, the marriage at Medinapur, could not be proved. The IO says that there is no record.
No record.
First part.
Yes.
And second, the Jagannath temple, who has attended? What is the proof of Jagannath temple marriage? Show me.
Yes, my lordship. In the cross-examination, he has said that I am.
Yes.
I'm reading out that paragraph 2. I'm reading out, my
Yes.
lordship.
Para?
From the first paragraph.
Yes.
Medinapur. Thereafter, it was also celebrated in the Jagannath temple of the Lord Jagannath at Medinapur. Accused Kakan stayed for 15 days in the house of Sadananda after marriage. Cash of rupees 20,000, utensils and other household articles were given when we left Mittu alias Mani in the house of the accused persons. After a month, accused Kakan and Mani came to the house of Sadananda. After 7 to 8 days of her stay, accused Kakan took Mani back to his house of the pretext that there had been a snake bite to his mother. Young sister of Mani had accompanied Mani to the house of the accused persons. Then Sadananda told that he had received information over the phone from the accused Kakan about admission of Mani at Baripada hospital. Sadananda and his wife came to the hospital. I had not come to the hospital. I ascertained from brother Sadananda that Mani poured kerosene on her body and set her on fire. She died in hospital during course of treatment. Police had interrogated me. Cross-examination. I am living separate from my other brother. I was not present when the marriage was registered before the marriage officer. On the date of registration of the marriage before the marriage officer, the marriage was also held in the temple. Held in the temple. Father of accused Kakan were present when the marriage was held in the temple. Parents of the accused Kakan came away after the marriage, but the accused Kakan stayed in the house of Sadananda. Mani stayed for 2 months with accused Kakan after coming from her father's house.
This is the uncle of the deceased. Any independent evidence
Independent witness also
regarding the marriage in the Jagannath?
they are saying
Rather,
we are seeing the
Honorable says he has not gone through the evidence with regards to the injury of the accused. The daughter-in-law told she set her fire by pouring kerosene. Accused Khokon was attempting to extinguish the fire. He had sustained burn injuries. Then accused Khokon became senseless and fell over me. The patient was removed.
Where is
PW7, madam.
7.
8th line.
Yes.
How my daughter has skipped over it.
Attempted to extinguish. Yes.
8th line.
Yes. Daughter-in-law told
that she has set fire on by pouring kerosene. Accused Khokon was attempting to extinguish the fire. He had sustained burn injuries. Then accused Khokon became senseless and fell over me. The patient was removed to the hospital on the next day. Police had interrogated me.
Here, my lordship said the daughter-in-law told that she set a fire on. He is an independent witness, ma'am.
Accepted as daughter-in-law in the house. I think so. But no marriage. She was supposed to be the daughter-in-law. The state.
Yes. Yes, madam.
Yes, my lordship. I'm confined to that, my lordship. All the independent witnesses are saying that she is the daughter-in-law and she is staying with the
Who are the independent?
another independent witness, my lordship. Who is the neighbor of the accused.
If the direct declaration matter would be disbelieved, then on the entire case will be disbelieved. Because then they have denied upon side.
My lordship, can you announce the PW6 also? PW6 is the independent person.
Let's see exhibit 4.
Exhibit 4 what?
Let's see, these are the dowry article, it seems seized.
That was also confirmed by the IO, my worship. IO has also said that the dowry articles has been seized.
This could be used as a corroborative evidence for the established marriage. If there was no marriage, where it's a question of giving dowry, and those dowry articles are seized. See the
silver flexi gote, silver कड़े गोटे, प्लास्टिक जग गोटे, पित्तल ग्लास गोटे, कंसा लोटा गोटे, पित्तल स्टील डंकी गोटे, स्टील कुटुणी गोटे, जुआ गोटे,
articles with 20,000 rupees. And those dowry articles are now seized by PW11, that by Exhibit 4. And it was the Zimma was given
list
to
of dowry
his father.
articles. List of dowry articles is not there. Already those articles which has been seized are very common things, madam. Nali rangoro sunna palla diti. Rupa bada diti, rupa chain gote.
No, that's right, but if this was seized and given Jimma to the father of the deceased, and in the you have not doubted that, you have not said that these articles are not belongs to them, rather it belongs to our household articles were taken. Reflected in the seizure
6 clause number 6 circumstance of the seizure. उपरोक्त केस तदंत समय रे विवाह समय रे ती मनीषा उपरोक्त जिनिस विवाह समय रे যৌতুক কিবা জিনিস সবু তার স্বামী কোপন সামান্য সাক্ষী ମାନଙ୍କ ସମ୍ମୁଖରେ ଦାଖଲ ଦେବାର ଜପ୍ତି କରାଯିବ।
ଜପ୍ତି 498 ହବ ନା?
The husband has put his signature.
No, come to page 83, PW 11, para 8. Read it. Hear it.
5%.
You have to carefully read the. I have to do your what? You read it.
Fourth line.
5% consist of the family members of the accused person, including the deceased daughter-in-law, who was the wife of the accused husband. Though the informant
This line, though the informant disclosed
the article given to the bridegroom and to the daughter,
bridegroom
no such list was
to the daughter, but no such list was produced. And how will relate that exhibit 4 with this?
Section
The cross examination, they could extract this sentence. Earlier there was no list, so it is not relatable. They need not elaborate. This much line they got it, they're happy. Why should they elaborate and get some adverse against them? that much what clears it out. They stop there. This is very intelligently they put it. If next question they would have asked, it would have been explained.
Answer.
So therefore, tactfully kept silent. Now the doubt is now created. Now the doubt is. This is the way the cross examinations are being done. The right way of doing it.
What to put, what not to put, and how to put.
So what I was trying to see, marriage is not true. Marriage is not true, except the evidence of the interested witness, uncle and all, they say that yes, in Jagannath temple it had happened. It is not an exclusive evidence. Next proof is whether dowry was given. If dowry was given, then marriage would have been there. That is a corroborative evidence.
That part.
Now dowry exhibit 4, and they exist, that is also created a doubt. So whether dowry articles were given or not, money given or not, nobody knows.
Nobody knows.
Only you said money was demanded.
PW5.
And what you have given? Dowry articles you have given. If you could have proved the dowry articles rightly given, then indirectly you could prove there was a marriage. And it would have been a corroborative evidence for the purpose of marriage. That is also lacking. That's what I am trying to impress upon.
Once the marriage is not proved, everything goes, my lordship. Sure.
That is what you have to tell me, whether how will you prove it?
My
Relate with
Yes,
your
my-
dowry article or otherwise marriage. See, because the biggest problem with you is first the marriage according to all the prosecution witnesses, father, uncle, mother, everybody says marriage taken place, registered marriage taken place in Medina.
It's not been seized.
It is not seized, not
Nothing
traced
has
out.
been to be produced.
So that part goes. And now what marriage? Jagannath
Jagannath
temple marriage. You say that after that we came and had a Jagannath wedding. For Jagannath temple marriage, there is no independent witness, the Pujari or whoever it is. Not that. Only the uncle and everybody says that we came and had a marriage. There is a doubtful. And now you have given a dowry articles. If the dowry articles were really given, if there would not have been marriage, no question of giving dowry articles. You that also you are not able to prove full proof.
But,
There is a doubt being.
but the Caesar has done, my lordship.
ଘରକୁ ଆସିଲେ
Seize control, but
କଣ
that's
ସିଜ୍ କରିଛନ୍ତି ଦେଖନ୍ତୁ କଣ ସିଜ୍ କରିଛନ୍ତି କଣ ସିଜ୍ କରି ଦେଖନ୍ତୁ କାହିଁକି ନାଁ ଲେଖା ହେଇଥିଲା ବାସନ କୁସନ ସବୁ ସିଜ୍ କରିଛନ୍ତି ତା ନାଁ ଲେଖା ହେଇଥିଲା ଯେ ସେ ଏଇ ବାସନ କୁସନ ସେମାନେ ଦେଇଛନ୍ତି ବୋଲି Then ଯଦି ଆପଣ ଆଗରୁ ଗୋଟେ ଲିଷ୍ଟ ଦେଇଥାନ୍ତେ ଏଇ ଜିନିଷ ଆମେ ଦେଇଥିଲୁ ବାହାଘରରେ ତାପରେ ସିଜ୍ ହେଇଥାନ୍ତା ତାପରେ କନେକ୍ଟ କରିଥାନ୍ତେ ହଁ ଜି ଆମେ ଏଇ ଲିଷ୍ଟ ଦେଇଥିଲୁ ଏଇଟା ସିଜ୍ ହେଲା ଲିଷ୍ଟ ଦେଇନାହାନ୍ତି ଆପଣ କେମିତି କନେକ୍ଟ କରିବେ ଆଉ accused once it is seized accused has to sign. Does he have any option? He doesn't have any option. Police says sign it. He has to sign.
Silver actually. Again, Dankodi. Costly.
Data, my lordship.
Let us see the father-in-law. Who is father-in-law? PW? One purpose. See, father-in-law has said what kind of outcome is given.
नहीं ये फेरे नहीं कि सेट नहीं 60 पर बेस 60 वाले
Paragraph 5 to the question, police seized some dowry articles in the house of the accused person and had given the same in the Jima of White Jimanama Exhibit 2 and 2.1 in my signature. That is in page number 61. Para 6.
Only he says that household articles. But what household articles, utensils or something, nothing is there.
And in para 62 also he says that my daughter was able to speak when I met her in the hospital.
He has been taken as a witness to the dying declaration, but he has not stated anything about identities. This Sadananda Khatwar is a signatory to the dying declaration, but not stated a single line with regards to dying declaration. Yes, in my presence, PW8 has University has recorded the dying.
And these two ladies, those who have signed in Bengali, they have been.
So, madam,
They
one
have
is
not been examined.
One's mother of the
Father has not been examined.
No. You see the magistrates.
Madam.
Just see.
Yes.
What the magistrate says. Who are there? Who has signed?
Sadananda Khatwar and mother.
mother.
Has not been examined. Sadananda Khatwar is PW1. PW8 has also stated these two names. My lord, Gita Sasmal.
One Gita Sasmal and Sadananda Khatwar have signed in Bengali.
Gita Sasmal is the mother.
Sadanand is the father.
Father. Is the father. And
Father.
Gita Sasmal is the mother-in-law.
Father-in-law the examination.
The accused.
Whose handwriting is this? The magistrate's own handwriting. Tehsildar. His own handwriting.
With father, mother, Bengal records of the geography, pure Odia records. Zero statement record kurchesi pura Odia. No certificate that it was in Bengali, I converted it to Odia.
Yes, madam, what do you have?
My lordship, in 313 statement also the mother-in-law and the husband accepting that she is my wife and mother-in-law is saying that she is my daughter-in-law. Because
That statement cannot be the basis.
that is not the basis because one question has been put to him that PW7 Umesh De has stated that the hearing hue and cry in your house and seeing gathering, this witness came to your house and saw your wife having sustained burn injuries and she disclosed that she burned herself by pouring kerosene. What do you say? And he said yes. One question put to him and mother-in-law also says that
Gitarani Sasmal is one of the accused.
yes, mother-in-law and husband. Both are accused.
Kokan Sasmal and Gitarani Sasmal.
Yes.
You come to magistrate.
But Gita Sasmal is valid of mother-in-law.
Mother-in-law.
He
Gitarani Sasmal.
has also been.
You the same. The accused is a signatory to the dying declaration.
No, man.
No.
Huh?
Yes, my lordship.
Yes.
She is there in the present of the
1 minute. See, if you come to 77, page 77 come. At the top. One Gita Sasmal. One Gita Sasmal and Sadanand Khatwar has signed and the same Gita Sasmal is an accused.
कोर्ट के कौन है?
Huh?
सीविता सासू ना कौन है?
What is this? Sadanand has been examined as PW?
One.
PW1.
Valid. He has not stated anything about dying.
No, just you clarified.
Valid.
The magistrate says one Gita Sasmal, okay, and Sadanand Khatwar, PW1, have signed in Bengali in the dying declaration, isn't it?
Okay.
And now come to your memo of the appeal. There are two accused. One is
Gita
Sasmal
Sasmal
and Gitarani Sasmal.
Gitarani Sasmal.
Then he is the same Gitarani Sasmal who is signatory to dying declaration. The accused himself.
That is not there. She cannot be the
So Lordship will see PW8 statement. That I on 392 I was working as an additional Tahsildar come executive magistrate.
What are you showing?
I'm showing that Gita Sasmal was present there when he was.
That is what I'm saying. Whether in a dying declaration the signature of the accused is there, one of the accused. That's what I'm asking.
Yes, ma'am. It is there.
You just clarify.
161 statement.
What is the mother's name? This is mother.
Yes.
Was examined as?
That is to be yes.
No, she was not examined.
This is mother was examined?
No.
Huh?
Not examined, but is there the examined?
But I think the same the accused has been made in witness
Yes, that is
to the
that
dying
issue.
declaration. Then everything goes.
Everything goes. She cannot be the
Accused can't be witness to the
or for all.
Because after that, magistrate also says that I don't know the relationship of.
Then how can if you make accused signatory to the dying declaration and read the same evidence against him? It's surprising. And therefore, I saw that Gita then co-accused. And let us see co-accused Gita Sasman's 52. Come to 52. And what is the question put to her in dying declaration?
With regards to dying declaration.
Question number 10.
Nine. It's a nine.
W7 Wednesday has stated that hearing due and cry in your house and seeing that this witness came to your house and saw your daughter-in-law Mani having sustained burn injuries and said disclosed that she burned herself by pouring kerosene. What do you say? She says of the. And
What will be the consequence if the accused is made to sign in the dying declaration? Whether that dying declaration can be read against the accused once he is witness to the dying declaration? Now it takes a different turn altogether.
How we done? This had not stopped to my mind. This had not come to my mind. Very question which goes to root.
Very root of it.
Very root of it.
The vital document on the basis of which the conviction is hinges upon. In that document, the accused was made to be a witness. Then the entire prosecution case collapsed there. Now find out and tell you. Unless you can show that the name of the mother of that means this lady, the accused, co-accused, mother-in-law, so-called mother-in-law.
Wife of one is Rabadi Fatwa.
Then she was throughout she was in the hospital. Where this girl was hospital, she was in the hospital, and you made her an accused, and made in the dying declaration you made as a witness. The case is completely now doubtful.
It's doubted mystery.
It is leading towards a clear acquittal. Just unless you told me.
Yes.
Where from you got the wife of Sadanand? What is the name?
The 161 statement.
Just see.
That is
Sadanand.
page number 156.
What does it say?
Statement of Rabadi Katwa. More Ramos Rabadi Katwa ସ୍ୱାମୀ ସଦାନନ୍ଦ ଖଟୁଆ, ଚୌକ ଜୟରାମ, ଅଂଶ ବେଦିନପୁର। ଆଜି ଆପଣଙ୍କ ପାଖରେ ବୟାନ ଦେଉଅଛି କି ମୋର ଝିଆରୀ
ଝିଆରୀ
ଶାସ୍ତ୍ରନଗରରେ ବିବାହ ହୋଇଛି।
ଝିଆରୀ
ଝିଆରୀ କହୁଛି,
mother of the
ୱାଇଫ
victim.
ଅଫ ସଦାନନ୍ଦ ଖଟୁଆ। ସଦାନନ୍ଦ ଖଟୁଆ ଇଜ PW1।
ଝିଆରୀ କେମିତି କହୁଛି?
ଝିଆରୀ କହୁଛି।
Here means that uncle Judah Tari wife is.
ନାଇଁ ସଦାନନ୍ଦ ଖଟୁଆ is the father. ସଦାନନ୍ଦ ଖଟୁଆ is
ସେ
father.
କହୁଛି ମୋର ଝିଆରୀ ଶାସ୍ତ୍ରନଗର ବିବାହ ହୋଇଛି। ମୟୂରଭଞ୍ଜର ଜିଲ୍ଲାର ସୁକାନ୍ତି ଗ୍ରାମର କନେଇଲାଲ ଶାସମଲର ଝିଅ ସେଇ ଗ୍ରାମରେ ବିବାହ ହୋଇଛି। ମୋର ନିଜ ଝିଅ ମିଠୁ ମୋର ଝିଆରୀ ଘରକୁ ଯାଉଥିଲା ବେଳେ ସଦାନନ୍ଦ ଖଟୁଆର ୱାଇଫ ଶ୍ରାବଣୀ। ସଦାନନ୍ଦ ଖଟୁଆ is PW1 and he says accused Saswal is my son-in-law.
My son-in-law.
And
Father
Saswal Khotwar says wife
his
of
father and mother.
Pilot may see 156 page.
Yes, really.
Page 156.
Up with what you call? Yes, 156. Shravani. Yes.
Right.
Mona Shravani.
Wife of Sadananda Khotwar.
Swami Sadananda Khotwar.
And Sadananda Khotwar is the informant. 40.
ଝିଆରୀ
ସେ କହୁଛି ମୋର ଝିଅ ଏଫଆଇଆର ରେ, ମୋର ଝିଅ ଏଫଆଇଆର ରେ ପେଜ 42
in 161 he says ଝିଆରୀ. A father mother is also doubtful. Find out. This is very.
And then PW1 is saying that that Sadananda Khotwar is saying this is Mittu alias Mani was my daughter.
Daughter, that's right. And if you come to the statement of Shravani, he is supposed to be the wife of Sadananda Khotwar. He says that my ঝিয়ারি. 161.
ଉପରେ ଝିଅ ଲେଖିଛି ନା ତଳେ ଝିଅ ଲେଖିଛି? କୋଉଟା ଠିକ?
ମୋର ଝିଆରୀ.
ପୁରା ତଳେ ଲେଖିଛି ସେ ମୋର ଝିଅ ସହିତ ଓପନର ପ୍ରେମ ସମ୍ପର୍କ ଗଢି ଉଠିଥିଲା।
ନାଇଁ ମୋର ବଡ ଝିଅ ମିଠୁ ମୋର ଝିଆରୀ ଘରକୁ ଯାଇଥିବା ବେଳେ କନେଇଲାଲ ନା ମିଠୁ ବଡ ଝିଅ ମିଠୁ ଝିଆରୀ ଘରକୁ ଯାଇଥିଲା ବେଳେ ଠିକ है there is no problem. Then Shravani is the name of the wife of Sadana. So therefore it is now sure that the co-accused Gita Samal is the signatory to the dying declaration.
But the additional Tahsildar doesn't know that she is the Gita Sasmal because he in the statement is saying that
one Gita Sasmal.
No. He is saying I don't know the relation. I had not ascertained their
That's right.
with the injured.
And he was made accused. Now what will be the evidentiary value of the dying declaration once the accused was made to sign in the dying declaration? Now this is the question. This is another question now today came out from the evidence. You find out that thing.
Very close.
I think I'll go with this. And now this part also, which now is found out from record, this also you have to give.
I'll give it to
right. And you find out, madam,
Yes,
and
madam.
the judgment which you are relying upon.
Yes,
read it and give.
Okay, this is for another item. There item 45. Can be taken up.
Today may not be possible to very full larger way. Larger way. So written note of submission to find out the within a week.
Yes, madam. Sure.
And I think all these things you have to highlight.
But I will give it. Sir, written note of submission.
Yes.